My lords, kindly peruse the last order, my lords, that is two orders, my lords, on 22nd 6 2022, my lords, that will give a summary of the, my lords, appeal. And my lords, subsequently on 3/8 on 2022, my lords has put a query whether this appeal should be heard by this bench or it should be referred to the coordinate bench, my lords.
No, roster is allotted to whom?
Lords, Lords, I would request Lordship to kindly peruse the order dated 22/6 2022, Lords.
No, as on that day, the roster was allotted to him, to the bench consisting of Justice Ashutosh Kumar and Jitendra Kumar. As on today, what is the roster?
No, perhaps it is before Lordship.
The roster is of my lords itself.
It has been clarified. Yes.
Lords, I would request Lordship to kindly have a peruse of order dated 22/6 2022. My Lords, that will give a brief summary of the case, Lordship.
Recovery is just 2 crore.
My Lords, so far as recovery is concerned, my Lords,
What is the post held by the petitioner respondent?
Sorry, Madam.
What is the post held by him?
he was Najiri, Lords, in charge of financial.
So he is worth of 2 crore rupees.
My Lords, that is the allegation, Lords, that by producing Lords false checks.
During his entire service, how much he can save? 2 crore.
Najid of what?
Social Welfare Office, Lordship, District Social Welfare Office, Lords, Darbhanga, Lordship. At that relevant time, he was posted as a Nazir in the District Social Welfare Office, Darbhanga. The allegation is that, my Lords, by forging the checks, he get all this money transferred to the relatives as well as, my Lords, the person known to him, Lordship. And personally, he went to the
Then
banks.
on what ground single judge has set aside?
My Lords, the London single judge has set aside on ground, my Lord, that certain witnesses were not examined, my Lords. Whereas, my Lords, our contention was that, my Lords, since all the transactions were electronically taken place, my Lords, no need for, my Lords, any person was required to be examined. My Lords, he himself went to the bank, he produced all the checks before the manager of the bank, and the money was transferred through RTGS to the account of, my Lords, two persons. Lords, from where the Lordship money was again, my Lords, some money was transferred in the account of the petitioner, my Lords, and my Lords.
Manager was examined that he personally came to the bank.
The manager, my Lords, yes, manager has given in writing that this person had, my Lords, come personally in the bank, my Lords, and he had produced all the checks before the bank, my Lords. In last time, when on last occasion when he approached the bank, my Lords, and then the signature did not match, then the manager informed the, my Lords, authorities, Lordship, that the check has.
So check is here.
Yes, Lords. Then it was detected, my Lords, he has already in the identical manner, he has produced 15, 16 checks, my Lords, and all the amount was transferred to RTGS in the accounts of two persons, my Lords, and.
Who are the two persons?
Two persons first, Lordship, they have also filed a complaint, my Lords. Those two persons in which account this amount was transferred, they also have filed a complaint before this petitioner that, my Lords, he induced him to get this account open with the understanding that 80% amount will be kept by this Najir and 20% amount will be given to those two persons in whose account.
Sir, we'll set aside and remand the matter.
My Lords.
For a departmental inquiry from the defective stage.
That is the, my Lord will also appreciate, my Lord, the learned single judge has clearly held that it's a case of no evidence. My Lord, the learned single judge.
They will adduce the evidence.
Yes.
My Lords,
They will adduce the evidence.
my Lord, that is that because, my Lord, no oral witnesses were examined.
Sir, all right, it will be the alleged allegation is relating to misappropriation of 2 crore and odd.
My lord, that is
And-
there
and you
because
being a
whatever
Najib.
indeed, my lord.
You being the Najib,
Indeed,
even
my lord.
otherwise you are
Sir,
accountable.
Supreme Court decision is
Ma-
there.
indeed, my
If the punishment order is set aside on technicality, matter is required to be remanded to the inquiring authority from the defective stage to commence.
My lord, that is there. ECIL is there to that extent. My lord,
Yes.
P.
K. Karunakar
Karunakar is
lord,
also there.
that is their lordship.
My
How
lord,
that judgment is not applicable to in your case?
the learned single judge has relied on Roop Singh Negi, your lordship,
All
for
right.
setting
Sir,
aside the
this
impugn order.
MD ECIL is a constitution bench matter.
Indeed, my lord. But my lord will also appreciate whatever assertion which the department is placing, the documents, that is the statement of the alleged manager, he was not examined, your lordship.
Sir,
The
for that purpose only matter would be remanded.
Sir, you answer to the department. वो 2 करोड़ कहाँ गया? उसका खर्च कहाँ हुआ? आप नहीं निकाले. You have not withdrawn.
my lord, I have
वो 2
specific.
करोड़ कहाँ गया?
My lord, I have in my show cause reply, I have
वही जवाब दे दीजिए. नया प्रोसीडिंग शुरू होगा, जवाब दीजिए.
The police has also investigated the
What
matter.
happened to the criminal case?
Lordship, the charge sheet has been filed against this petitioner, Lordship, and it is on the
And others-
stage of appearance,
And
Lordship.
2 others.
And what
And
about
two
the
others.
bank official?
Yes.
My lords, as of now, my lords, preliminary on the basis of the preliminary investigation, 2 charge sheet against 2 persons have been filed, including this petitioner, and for the rest, lordship, the investigation is still going on, my lords.
Without the connivance of the banks,
My lords,
it
that
cannot be done.
That's why investigation is not concluded, lordship. Still, it is going
Sitting
on.
singly, I can see the lady retired professors of Muzaffarpur. The bank connived and crores of rupees have been withdrawn.
Of light.
My lord, that's why the inquiry officer in the inquiry report has recorded, because my specific contention before the learned writ court was also that the inquiry report is inconclusive. At the final
Sir,
part
that
of,
is the reason from the fresh inquiry shall be held.
my lord, the matter be remitted
We are
back
not
on
directing
with
you
the
to
on
pay.
the stage of defective stage, my lord.
Yes.
As my lord pleases, my lord. Because one of judgment was of my
No,
your lordship.
charge memo is in order.
My lords,
Charge memo.
charge memo was in order.
Have
My
you,
lord-
statement of imputation is there?
My lord, the,
Statement of imputation is there.
Lords,
my lord, even the charge
Sir,
memo.
you people don't read the rules.
my lords,
Do you know? For imposition of major penalty, what is the procedure?
lords,
Which is that? Bihar CCA rules. In that rule, there is a provision providing article of charge, statement of imputation, list of documents, list of witnesses. All those things are made available to him.
yes, lordship. There was no
Shall I record?
lordship. There was no infirmity in the lordship proceedings, lordship. Everything was lords. I have also given the date of lords.
Yes, take down.
My lord, it is not in accordance.
The present appeal is by the state in assailing the order of the learned single judge dated 10/5/2018, passed in CWJC 5243 of 2018. The respondent Sagar Kumar Roy, while working as a Nazir, he is alleged to have misappropriated a sum of rupees 2 crore 5,60,000 in connivance with the bank officials, arising out of the aforesaid alleged allegations. Respondent was subjected to parallel proceedings like departmental inquiry and criminal case. Criminal proceedings are still pending consideration before the jurisdictional forum, whereas the departmental inquiry was concluded in imposition of penalty of
Dismissal, lordship.
dismissal,
Lordship.
penalty of dismissal, and ordering recovery of 2.5 crore. Feeling aggrieved and dissatisfied with the order of the dismissal and recovery, respondent invoked remedy under Article 226 in filing CWJC 5243 of 2018 To stop. The aforesaid writ petition was allowed in favor of the respondent on 10/5/2018. Hence, the present appeal by the state of Bihar. To stop. Next part. Learned counsel for the appellant vehemently submitted that it is a serious case relating to misappropriation of a huge amount of rupees 2.5 crore and odd. If the learned single judge has set aside the order of dismissal, order of penalty of dismissal from service and recovery on technicalities, in such an event, matter is required to be remanded to the disciplinary authority to commence inquiry from the defective stage and conclude within a period, within a stipulated period. To stop. Next paragraph. Learned counsel for the respondent resisted the aforesaid contention and submitted that it is a case of no evidence and no witnesses have been examined. To stop. It is also submitted that even though list of witnesses have been cited along with the article of charges, however, none of the witnesses have been examined in support of the alleged charge.
My lord, there were no witnesses cited in the article of charges. It is utter violation if Rule
That is what
17
I am
subclause
asking
4.
you.
My lords, my learned friend just may produce that charge memo, my lord. It does not stipulate
Lords,
any witnesses.
I had submitted that since all the transactions have taken place.
Sir, have you adhered to the CCA rules or not? CCA rule says that you have to produce, furnish.
My lords, had there been any witnesses, lordship?
Sir, you are relying on XYZ documents.
Lords.
Author of those documents are required to be examined.
My lord, that was there, lordship. That was not examined.
Therefore, you have to frame fresh charges. It is also submitted that list of witnesses have not been made available. Therefore, there is a defect from the initial stage while issuing article of charges under Bihar so and so CCA rules 2005. Next paragraph. Further learned counsels for the respective parties. Perusal of the records, it is crystal clear that there is a serious alleged charge relating to misappropriation of 2 crore 5,60,000 and odd. To stop. If the disciplinary authority has committed certain error on certain error in not following the relevant CCA rules from the stage of issuance of article of charge, statement of imputation, list of documents and list of witnesses, and further there is no examination of witnesses in such an event. Entire proceedings were required to be set aside and matter is required to be remanded to the disciplinary authority to commence fresh inquiry from the defective stage. To stop. The next part, learned single judge has committed error in not noticing the apex court decision in the case of MD ECIL versus so and so, coal authority so and so, para 46 to 50. To stop. In fact, it was bounden duty of the state council to apprise the learned single judge about remanding the matter if the proceedings are set aside on technicality. However, the same was not brought to the notice of the learned single judge. Full stop. Therefore, order of the learned single judge is modified to the following effect. Full stop. The matter is remanded to the disciplinary authority to commence inquiry afresh in terms of CCA rules 2005. To stop. This court has come across now and then there is a one or the other legal issues which have been ignored by the disciplinary authority / inquiring authority / appellate authority. To stop. Here is a case relating to alleged allegations relating to misappropriation of 2.5 crore and odd. Full stop. Therefore, the order of the learned single judge is modified to the extent of remanding the present matter to the disciplinary authority to commence a fresh inquiry and conclude within a period of 6 months from the date of receipt of this order. The disciplinary authority / inquiring authority are hereby directed to provide ample opportunity of hearing to the respondent. Full stop. At the same time, respondent shall cooperate in the inquiry to decide the inquiry proceedings within a period of 6 months. Full stop. Next paragraph. In the light of paragraph 46 to 50 of the Coal India decision, the disciplinary authority is hereby directed to take a decision as to whether respondent shall be reinstated into service or he should be suspended. Full stop. If he is reinstated or suspended, such order shall be subject to outcome of the final order passed in the departmental inquiry. Full stop. The intervening period from the date of dismissal till a final order to be passed by the disciplinary authority shall be regulated in accordance with law within a period of 6 months. Within a period of 1 month from the date of passing a final order in a departmental inquiry. Insofar as the reinstatement or a suspension is concerned, the disciplinary authority is hereby directed to pass speaking order and communicate to the respondent within a period of 1 month from the date of receipt of this order. The copy of this order shall be given to this Chief Secretary. Full stop. He is requested to formulate guidelines in respect of implementation of CCA rules to the heads of the department and secretariat level who are appointing authority / disciplinary authority in respect of a particular employee / officer. Full stop. We suggest for violation of CCA rules, we suggest that a disciplinary authority or any other authority who invokes various provisions of CCA rules in a disciplinary proceedings, and if they sidetrack such a mandatory provision and proceed to pass orders in a disciplinary proceedings, they must be liable for penal action under the very CCA rules to stop. In that regard, state government must examine whether penal action is warranted in respect of a disciplinary authority / appointing authority who invoke various provisions of CCA rules or not. In such an event only, disciplinary / appointing authority would be alert in invoking CCA rules in respect of initiation and completion of disciplinary proceedings against officer / employee of the state to stop.